Ladies and gentlemen, what you're about to hear is not just another routine courtroom exchange. This is the kind of moment that legal historians, constitutional scholars, and political analysts will be talking about for years. Imagine a federal courtroom in Washington, D.C., the marble floors polished, the air buzzing with tension, and every seat filled with professors, journalists, and legal observers who knew they were about to witness something significant. But even they had no idea just how historic this moment would become. Before we dive into this incredible legal drama, I want you to do something important. Hit that subscribe button, tap the like button, and drop a comment below with your thoughts on whether you think campaign finance laws should be treated as free speech or as barriers to democracy. Trust me, you won't want to miss what happens next, because what unfolded in this courtroom may very well reshape the way America understands its Constitution. The scene opens with federal judge Tanya Chutkan, a woman whose very presence commands respect. Known across the legal community as a jurist with razor-sharp intellect and zero tolerance for political grandstanding, she had built a reputation for cutting off attorneys who dared to enter her courtroom with arguments that lacked constitutional precision. To many lawyers, a few minutes in front of Judge Chutkan was more intimidating than hours before an appellate panel. She was, in every sense, the guardian of constitutional seriousness. Across from her stood Congresswoman Jasmine Crockett, a politician with a surprising edge, 15 years of courtroom experience as a criminal defense attorney. Crockett had overturned wrongful convictions, uncovered overlooked precedents, and built her legal career on spotting what others missed. But today, she wasn't here to make political speeches. She was here as amicus counsel, armed with research that promised to challenge decades of constitutional thinking. As Crockett began her opening, Judge Chutkan leaned forward, ready to dissect. But before Crockett could even finish her first line of argument, Chutkan cut her off. Miss Crockett, this court has heard every variation of First Amendment reasoning in campaign finance cases. Precedent is clear, and this courtroom deals in law, not political opinion. Her words were sharp, her tone unwavering. It was a judicial dismissal in real time, a warning that political theater would not survive here. The courtroom fell silent. Observers exchanged glances, certain Crockett would fold under the weight of Chutkan's authority. But what they didn't know was that Crockett had anticipated this exact moment. In her briefcase rested a document, pages of constitutional analysis so detailed, so groundbreaking, that it would turn skepticism into shock and silence into history. This was no longer a routine case. This was the beginning of a constitutional confrontation that would challenge the very foundation of electoral law in America.
To understand why this courtroom clash was unlike any other, you have to know the two figures at the center of it all. On one side of the bench sat Judge Tanya Chutkan, a federal jurist whose reputation was forged in the fire of constitutional precision. On the other side stood Congresswoman Jasmine Crockett, a politician with the instincts of a seasoned trial attorney. Both women carried decades of experience, but from vastly different worlds. And in this moment, those worlds were about to collide. Judge Tanya Chutkan's journey to the bench is legendary in Washington legal circles. Born in Jamaica, educated at the University of Pennsylvania Law School, and sharpened in the crucible of the D.C. legal system, she built her career on discipline, intellect, and an uncompromising devotion to constitutional law. As a federal public defender, she earned respect for fighting uphill battles, mastering constitutional criminal procedure, and outmaneuvering prosecutors who underestimated her. When she was appointed to the federal bench in 2014, colleagues knew she would bring that same relentless rigor to her courtroom. Her trademark? Intolerance for fluff. Attorneys who arrived with thin arguments, political rhetoric, or weak citations rarely lasted long before she cut them off mid-sentence. Lawyers in Washington used to joke that Judge Chutkan doesn't just hear cases, she dissects them. And on this day, she was prepared to do exactly that. Now, enter Congresswoman Jasmine Crockett. Many in the room knew her as a firebrand politician, sharp with her words on Capitol Hill. What fewer realized, until now, was that Crockett had spent over 15 years in the trenches of criminal defense law. She wasn't just a legislator, she was a fighter who had walked into federal courtrooms and left with overturned convictions, freed clients, and constitutional precedents others had overlooked. Her edge came from an unusual combination: political insight paired with trial experience. While most politicians wield rhetoric, Crockett wielded legal citations and courtroom instincts. She had seen how laws passed in Congress played out on the streets and in the courts. That perspective gave her a rare dual vision: one foot in the halls of power, the other in the trenches of justice. The collision between Chutkan and Crockett was inevitable. One represented the entrenched authority of the judiciary, steeped in precedent and precision. The other embodied the disruptive force of political experience fused with legal scholarship. Their encounter wasn't just a hearing, it was a test of whether constitutional innovation could stand against judicial orthodoxy. As Crockett adjusted her papers and prepared to respond to Chutkan's sharp rebuke, the audience leaned forward. The battle lines were drawn: precedent versus innovation, authority versus defiance, judge versus Congresswoman. The question was no longer whether Crockett could withstand the judge's skepticism. The question was, could she change the judge's mind? The stage was set for one of the most riveting constitutional exchanges in modern federal history.
The courtroom air was thick with expectation as Judge Tanya Chutkan leaned back in her chair, her tone sharp and decisive. Ms. Crockett, this court has reviewed the First Amendment arguments at length. Precedent is clear. Political speeches dressed as constitutional reasoning will not survive here. Her words echoed through the chamber like a gavel strike. For most attorneys, that kind of rebuke would signal the end of the road. But Jasmine Crockett was not most attorneys. The case before them, Citizens United Reform Coalition v. Federal Election Commission, had already drawn national attention. At its core, it tested whether federal campaign finance laws, regulations designed to prevent corruption and protect electoral integrity, violated the First Amendment's guarantee of free expression. Scholars, pundits, and politicians were split down the middle. Some argued that money was speech and therefore deserved maximum protection. Others insisted that without restrictions, wealthy interests would drown out the voices of ordinary voters, undermining democracy itself. It was the kind of constitutional puzzle Judge Chutkan was known to navigate with surgical precision. To her, the framework seemed straightforward: weigh the government's interest in fair elections against the individual's right to free expression. The Supreme Court had already spoken in Citizens United v. FEC, and she expected any lawyer stepping into her courtroom to respect that precedent. But Crockett had come prepared to change the conversation entirely. She adjusted her glasses, placed her hand on her portfolio, and spoke with calm conviction. "Your Honor, the First Amendment is only part of the story. This case cannot be resolved without considering the 15th Amendment and equal protection principles that safeguard democratic participation." A ripple moved through the audience. Law professors exchanged quick notes. Reporters glanced at one another. This was not the standard argument they expected. Crockett pressed forward. Campaign finance laws, as applied, don't just regulate speech, they create wealth-based barriers to participation. The Supreme Court has long held that such barriers, whether through poll taxes or filing fees, undermine the very foundation of democratic equality. Chutkan's expression shifted. Her skepticism softened into something else: curiosity. The judge who had moments earlier cut Crockett off now leaned in as though re-examining the battlefield. Crockett wasn't offering political rhetoric. She was weaving together constitutional provisions into a framework that had been overlooked. This was no longer a routine clash over campaign finance. It was a collision of constitutional visions, one rooted in the traditional balancing act of free speech versus regulation, the other reframing the debate around access, fairness, and equality under the law.
For the first time in that packed courtroom, it wasn't clear who held the upper hand, the judge with her fortress of precedent, or the Congresswoman with her arsenal of overlooked constitutional connections. The clash was just beginning, and everyone knew the next move could change the trajectory of the entire case.
The tension inside the courtroom was palpable. Judge Tanya Chutkan had just pressed Crockett with the kind of question that separates creative arguments from constitutional frameworks. Ms. Crockett, how do you reconcile your 15th Amendment analysis with established First Amendment doctrine? This was the moment where most attorneys faltered. Judges asked such questions not to be convinced, but to expose weaknesses. It was a test, sharp, precise, and potentially fatal to any novel theory. The audience leaned in. Scholars adjusted their glasses. Journalists readied their pens. Would Congresswoman Jasmine Crockett retreat under pressure? Instead, Crockett smiled. She had been waiting for this. With steady confidence, she reached into her portfolio and pulled out a meticulously prepared brief, thick with citations, neatly tabbed, every section crafted with surgical precision. Her voice carried clarity and conviction as she addressed the bench. Your Honor, I anticipated this question. What I have prepared is not a political statement, but a comprehensive constitutional analysis spanning decades of Supreme Court precedent. Together, these cases establish a pattern that has been overlooked when campaign finance is discussed in isolation. She approached the bench, document in hand. Judge Chutkan, who had moments earlier dismissed her argument as political, now nodded with unmistakable interest. Crockett handed over the brief. The silence in the room was broken only by the rustle of pages as the judge began to read. Inside that document lay a roadmap through American constitutional history. Harper v. Virginia Board of Elections, 1966, where the court struck down poll taxes as unconstitutional wealth-based barriers. Lubin v. Paynish, 1974, invalidating candidate filing fees that priced ordinary citizens out of political participation. Northwest Austin v. Holder, 2009, reinforcing that restrictions on democratic access must face the highest level of scrutiny. Case after case, the pattern became undeniable. Crockett's voice guided the courtroom through her findings. Your Honor, when campaign finance laws create wealth-based hurdles, they don't just regulate speech, they replicate the very barriers the court has consistently condemned under equal protection and voting rights jurisprudence. That requires strict scrutiny, not the intermediate standards typically applied. Judge Chutkan's brow furrowed as she flipped through the pages, her judicial skepticism slowly giving way to something rare, recognition. This was no empty rhetoric. This was scholarship, refined and battle-tested, the kind of argument that could not be ignored. Observers could feel the shift. The balance of power in the courtroom was changing. Chutkan, the judge known for cutting down flimsy arguments, was now leaning into Crockett's logic, seeing a constitutional framework emerge before her eyes. What began as a dismissal had transformed into respect. For the first time, the possibility was real. Jasmine Crockett's document might not just support her case, it might redefine the very way courts approach campaign finance law.
The gavel never struck, but the silence in the courtroom carried the weight of history. Judge Tanya Chutkan, a woman whose reputation had been built on unwavering precedent and uncompromising intellect, sat with Crockett's document in her hands. Her expression was no longer skeptical, no longer dismissive, it was contemplative. That shift alone told the story. Congresswoman Jasmine Crockett had done what few attorneys ever manage. She had not just presented an argument, she had moved a federal judge. Within minutes of that session ending, the ripple effects began. Legal scholars who had packed the courtroom wasted no time pulling out their phones and laptops, firing off early analyses. Crockett's integration of First and 15th Amendment doctrine is unprecedented, one professor whispered to a colleague. Another muttered, if this holds, it could reshape campaign finance jurisprudence for a generation. By the time the evening news rolled around, headlines were already calling the exchange a watershed moment. Law schools began circulating Crockett's brief among students, not as political theater, but as serious constitutional scholarship. On Capitol Hill, staffers buzzed about what it meant for campaign finance reform. And across the legal community, a single question echoed. Had Jasmine Crockett just shifted the ground beneath one of the most controversial areas of constitutional law? Judge Chutkan herself gave the most telling signal. Instead of brushing aside Crockett's argument, she acknowledged it publicly in court. Ms. Crockett, your constitutional framework presents questions this court must give serious consideration. For a federal judge to admit that her own analytical path had been challenged was nothing short of extraordinary. In that moment, Chutkan was not merely a gatekeeper of precedent. She was a scholar engaging with new constitutional thought. The impact went further. Commentators noted that Crockett's argument transcended party lines. Whether one believed campaign finance laws were necessary to curb corruption or whether one saw them as restrictions on free speech, the brilliance of her approach was that it reframed the debate entirely. This wasn't just about money as speech. It was about equality as the foundation of democracy. And so, a congresswoman turned amicus litigator had walked into one of the toughest courtrooms in the nation, faced a skeptical judge, and left with history on her side. The case was not yet decided, but the precedent was already being set. Fresh constitutional vision could emerge from unexpected places. Ladies and gentlemen, that's how Jasmine Crockett didn't just survive Judge Chutkan's cutoff. She turned it into one of the most significant legal moments in modern history. A reminder that the Constitution is not frozen in time. It lives, it adapts, and sometimes it surprises even the sharpest judicial minds. And now I want to hear from you. Do you believe campaign finance laws are protecting democracy, or do you think they're undermining it? Drop your thoughts in the comments below. If you enjoyed this breakdown of one of the most dramatic constitutional showdowns in recent memory, make sure you like this video, share it with friends, and subscribe so you never miss another deep dive into the legal battles shaping America's future. History just unfolded in real time, and together we'll keep uncovering the stories that matter most.